I'd like to introduce Eddie Cubillo for the next talk. Eddie is from the law school. He's an Aboriginal man with strong family links in both urban and rural areas throughout the Northern Territory. He is of Larrakia and Wajigan and Central Arrernte descent. Eddie has a Bachelor of Laws degree and was admitted to the Supreme Court of the Northern Territory. Throughout his career, Eddie has been involved with a number of organisations and causes, including the National Aboriginal and Torres Strait Islander Legal Service and the Royal Commission into the Protection and Detention of Children in the Northern Territory. He recently submitted his PhD and is working at the University of Melbourne Law School as Associate Dean and Research Fellow and Senior Research Fellow in the Indigenous programs. Thank you, Eddie.
Thank you, Michael. Can I acknowledge the Wurundjeri peoples of the Kulin Nations and other nations in Victoria and all nations across the country. As Michael pointed out, I'm a proud Northern Territory Aboriginal man, again from the Larrakia, Wajigan and Central Arrernte peoples. And I must say that I'm proud of the resilience of our people and the capacity to that they've endured the hardship and the fight for our recognition as First Peoples of this nation. From all the adversity our people continue to face, they continue to speak or regain our languages, culture and laws. As we're talking about knowledge, Indigenous knowledges, I want to relate to people that I have, like most, more moved away from country for work purposes, to advocate for our people. Also as to equip ourselves with skills and qualifications that non-Indigenous Australians respect. In my case, I've got a law degree, a master's in law, and as I said, I've been admitted as a practitioner in the Northern Territory, and I've recently submitted my PhD examination. In saying that, I've also sent my kids away to arm themselves to become better educated, and both of them have tertiary degrees. So they can be prepared for the treatment our people confront daily and educate others on the realities of being Indigenous. But I want to stress that, what we gain in non-Indigenous education from such institutions sees us lose extremely valuable learnings from our families, our country, our culture, our language, and so on. It appears that we are always giving with not much in return. And I've seen over the years that it's like a balancing act with sometimes bring criticism from both sides, which has a huge impact on our well-being. So now that's the way I just wanted to start my discussion on the justice industry. And in doing so, I would like to tell a story which emphasises the underlying systemic racism and how ingrained this bias is that underpins the justice industry, and as such speaks to the why. It was, back in 2002, I was sitting in the front row of court, a recently admitted lawyer, waiting for proceedings to commence. I was really nervous. It was a Monday morning, which meant, the weekend offenders, which I knew many, were waiting to be heard. A court orderly approached and advised me that as the front row was for lawyers and I should move into the second row and sit directly behind my lawyer. Now, if we jump forward some 18 years later, I was sitting again in the same court, working on the Royal Commission into the protection and detention of children in the Northern Territory. I was waiting for a client to finish his matter so that we could follow up his evidence. The room was empty except for some lawyers and this client. The lawyers had just given myself and my colleague a welcome nod, as we both had worked together over many years in the justice system up in the Territory. And a court orderly, on seeing us wandered over, they again asked whether I was on today's court list and if I was in the right court. And look, that's almost some 20 years later. But before I could reply, my colleague, who also was Indigenous, and a lawyer, produced his Royal Commission ID and advised that we'd both be working on the Royal Commission. Now, I just want to highlight that these type of incidents aren't aren't one out, you know, they're fairly regular when you're working in the justice system. And I, as an older gentleman now, I've grandchildren, and you know, I'm obligated to make sure their place in family, their connection to country, and their cultural obligations. It's not easy, you know, to do so in the current environment for Indigenous people to keep up with these challenges, to make sure that our kids learn the importance of our people, our land, our culture, our languages, when there's so much unjust negativity towards us and no willingness to respect our values and way of life. You know, a good friend told me that her elder said to her when she started university, don't let your studies get in the way of your education. And this rings true to me, and I've always tried to incorporate all my practical learnings and experiences into either my writings and teachings. So I just want to speak more about the justice industry. Recently, I wrote a piece for the Alternative Law Journal. As most Indigenous people know, April this year was the 30th anniversary of the tabling of the Royal Commission into Aboriginal Deaths in Custody, which I'll call Rikki from here on. And for our people, things are worse than they've ever been when dealing with the justice industry. Can I ask to put that slide up, please? I'm not sure if you can see that, but those are the current stats that are, you know, shows where our people are at this time. At the time of writing this piece, The Guardian had put these grim totals of First Nations people in custody at 474 since the Rikki. Now, I despair the lack of progress made, and evidence, as you can see there, suggests that things have changed for the worse since the Rikki report and its 339 recommendations were released. You know, this despair resonates with the findings of the 2018 Australian Law Reform Commission Pathways to Justice report, in which the commissioners there explained and examined the multiple and layered nature of entrenched disadvantage we face in social, cultural and economic spheres. The Commonwealth Government has never publicly responded to this report. And, you know, working in the space for such a long time, I've thought long and hard about whether this practice of appointing bodies and then ignoring them is a deliberate strategy of distraction designed to keep our people occupied and engaged with these serious problems, but always kicking our response down the road to some future government. Now, racial discrimination plays a huge part. The Rikki report made it clear that racism is a fundamental cause of high rates of incarceration and deaths in custody, explaining that it is institutionalized and systemic and resides not just in individuals or individual settings, but in the relationships between the various institutions. And we've got to remember this report is 30 years old and is still current in what it says. A good example is the coronal exposures of these systemic failures. There have been many coronal inquiries that have highlighted the impact of systemic shortcomings in the health and justice sectors. I'm going to give two examples here, but there are obviously many more. Firstly, the Miss Dew coronal. Here, the coroner found that Miss Dew death could have been prevented if her illness had been diagnosed earlier and she'd been given antibiotics, adding that her overall care was below expected standards. The doctor who declared Miss Dew fit to be detained before she died in police custody has now been ordered to pay a $30,000 fine for providing inadequate and substantially below standard care. The State Admin Tribunal for Western Australia declared that the 2014 death of Miss Dew demonstrates the serious and tragic consequences of racism in our health and justice systems. The tribunal fined the doctor for professional misconduct, but he's not been suspended from practicing medicine. And that just reinforces the concerns around here. We must also remember that Miss Dew was only apprehended and held in custody because she failed to pay fines. And police testified that they thought she was faking the illnesses and coming down from drugs. Well, some of the medical staff also thought she was exaggerating her behaviour. So the other coronial I wanted to quickly discuss is Kumanjay Langdon, who was a respectful Aboriginal man from Central Australia. He died in Darwin's police cells after being taken into custody for minor alcohol-related offences. He was detained under the paperless arrest police powers. He was found dead in his cell about 3 hours later. Here, the coroner was informed that Mr. Langdon was kept in custody for having committed the offence of drinking in a regulated place in a designated area. And look, I'm from the Northern Territory, and if you go to the beachfront, you'll see non-Indigenous people drinking as much alcohol as they want, and no one's being locked up. So, we're looking at biases here. And the coroner highlighted that while no court could have locked Mr. Langdon up for that offence for any period of time, it was under these laws that implemented by the NT government, the police can exercise their discretion to do so for a period of up to four hours or even longer if they determine that the individual was still intoxicated. The coroner went on to say, and I think this is prevalent, that a sick middle-aged Aboriginal man was treated like a criminal and incarcerated like a criminal. He died in a police cell which was built to house criminals. He died in his sleep with strangers in this cold and concrete cell. He died of natural causes and was always likely to die suddenly due to chronic and serious heart disease. But he was entitled to die in peace in the comfort of family and friends. In my view, he was entitled to die as a free man, said the coroner. These laws are covertly target our people and are racially biased, and they don't afford our people the same discretion that others receive from police and even sometimes the judiciary. If we are serious about addressing the extreme overrepresentation of Aboriginal people in the criminal justice system, we need to ensure that this system is meaningful for and relevant to Indigenous people and respect, their status as members of the First Nations, the original Aboriginal Australian sovereigns. This is not to advocate a separate judicial system for Aboriginal people, but rather recognition that the justice system is failing Indigenous people, and that there needs to be a serious consideration of the overhaul required to make it equal for all. Look, and I want to stress that customary law is not a historic artifact. It guides people in community, on country, in real and concrete ways, emphasising responsibilities that we must look after one another and care for country. Indigenous Australians cannot help but feel, the irony of statements made by the rule of law and one law for all when they bear the brunt of criminal justice laws that are, apparently universal on the face of it, but, are typically deployed, to control and coerce Indigenous peoples and all peoples of low socioeconomic backgrounds. The move on laws, for example, are rules enabling, paperless arrest and impose laws prohibiting the possession of alcohol in Indigenous communities. The systemic and structural biases are inherent in both the laws themselves and their application work to criminalise Indigenous Australians. Such laws, they operate in two different ways in practice. They are effectively two laws treating Australians differently depending on whether they are or appear to be First Nations people. Time after time, governments have failed to properly implement recommendations arising from, deep and thoughtful inquiries and research that they've initiated. I reflect on my learnings as a law student, being told from my first year that law is fair and just, and it did not then, and nor does it now, reflect what I experience and perceive as an Indigenous person in this country. The theory and the history of settler law reflects a self-reinforcing system that, is designed to basically justify continued settler supremacy. Our people and our justice systems were here prior to what colonialism, and which has ignored or disrespected them ever since. Perhaps this is because the inherently illegal nature of the occupation has yet to be addressed, including through relatively benign measures such as recognition of customary law. The presence of peoples with sovereignty and legal systems of their own belies the premise that Britain acquired sovereignty over land by settlement. This is a legal fiction and does not, borrowing a phrase from Brennan in Mabo number 2, accord with our present knowledge and appreciation of the facts. Is it time to take up the challenge to developing the Australian legal systems in ways that the court in Mabo number 2 declined to? Those are the questions. Is it to acknowledge Indigenous law and legal authority? In my opinion, until we do, the flaws in this foundational legal fiction, is my time there, legal fiction continuing, affect the entirety of Australia's legal system. I'll probably leave it there with just saying, Professor Mick Dodson described it perhaps too diplomatically when he said that the sovereign pillars of Australian state are arguably at their very least a little legally shaky. Michael has got a bit more time, or is that it?
We're right on time, mate. So unless you can part with a few words if you want to sum up.
Yeah, I just want to get to this party where in Mabo number 2, much attention was devoted to the idea that the common law must develop to reflect contemporary notions of justice and human rights, but not in ways that fracture a skeletal principle of the Australian legal system. As Brennan pointed out in that rule, that is pegged for a change must be assessed to see whether it's essential in the sense of being skeletal. We are told that any rule that seriously offends the value of justice and human rights, especially equality before the law, cannot command unquestioning adherence, but also that in weighing up the pros and cons of changing a rule, we must ask whether if the rule were to be overturned, the disturbance to apprehend would be disproportionate to the benefit flowing from the overturning. But to my mind, this is essentially the dilemma. In the criminal justice system, there are many rules and practices that do not accord with the equality before the law. So their persistence seems tied in some ways to the idea that overturning them would result in a disturbance disproportionate to the benefit. And then you've got to ask as Indigenous people whether the benefit to whom. And it's not to us who lost lands, family, languages, cultures at the hands of this settler law. And I'll leave it at that.
Thanks, Eddie. Really thought-provoking stuff and some sobering stories you've mentioned there. There's so many questions in my head and a few on the Q&A. Just if you could quickly, we'll do 2 quick ones and then we'll call it for afternoon break. It seems as though, particularly in the case you said about the man who died in custody after having drinks in a publicly excluded place, where do we need to best focus our energy? It'd be great if we could focus it in all directions. It seems as though, is it the policing and their interpretation of what they need to do, or do we first go at fundamentally changing the law? Like, do we need, what's the path forward here immediately?
Well, that's a huge question, and you could quickly do stuff if you just change the bail act and the sentencing act, and also the age of criminal responsibility. You could really make some huge differences. But overall, the law in itself, we can just see the Northern Territory had a Royal Commission to in regards to the children protection and juvenile justice, and it's only been 3 or 4 years since that Royal Commission, and they've gone tough on crime, and they've sort of just ignored the whole 227 recommendations that has been given down. And so, and if you go on in the paper that I wrote, I get to Chief Justices who, for them to come out and talk about the system and that the unconscious biases are there for Indigenous people. So it must really say there's something wrong with the system. And I've said in numerous other talks that the profession has been complicit in how, you know, these numbers are such high and going on from where it is. And don't get me wrong, they've all done submissions and etc. But the reality is, where do they go next? And you know, I put it on them that they need to be doing more than just writing submissions now. We're past that stage, and I talk to you back to the foundational of the laws of this country. I think we really need to go that way. And earlier we had you know, Marcus and they're talking about treaty, and I mean that's one way of trying to make that change, but also, you know, the voice that is trying to look at the constitution and structural reform is also a huge need in this country, I think, for Indigenous Australians.
Yeah, cool. And that feeds into a quick question, I guess, if you just give a couple of words on the whether the treaty process is heading in this direction, but how far away do you think we are from recognising that Australia is a legally pluralist place? Is this where the treaty process is going, or are there other ways to get there?
Man, you ask hard questions. I mean, so I've been involved with the Treaty Assembly in discussions around this stuff, and I think that is a process where they can have discussions around, but the thing you don't want to also do is take responsibility away from government, you know, and then be lumped with something that you really can't, you know, do yourself. And the reality is that there is already legal pluralism in this country. You know, we've got mob all over this country who are on country, who would not know what's going outside of their community other than, you know, watching the footy or something, who practice their daily laws and cultures like they've always done. So there's no denying that, but I think it's a bigger picture around, if you look at the High Court, they're still reluctant to question that sovereignty question, and the recent Love Tom's case also goes there. So I think people are, you know, relearning their languages and culture. So it's an issue for this country, and they need to accept that there is, you know, legal pluralism in this country.
Yeah, really, really important, I think. Thanks a lot, Eddie. Really, really amazing stuff and powerful narrative.